The question is that the bill be now read the third time. Mr. Pete Wishart.
Speaker, and can I once again, and this is now get to become a feature, to congratulate my right honourable friend for progressing this bill through the House with such dexterity and skill and consensus, and welcome the fact that now, after today, this will soon become law. Can I also just extend the congratulations he had to everybody involved, particularly the Minister, who I think I mentioned in my earlier remarks has been nothing other than consensual, effective and efficient in ensuring that this bill's got through the House, and everybody else who was on the Bill Committee with the right honourable gentleman. And for me, this bill can't come soon enough. We need a firm code of practice that will constrain the worst excesses of these private parking companies. I don't know what Perth's done to deserve the attention of some of the more sharper practices of the parking operators, but we have been far too long blighted by some of the worst excesses of these parking operators, and they almost act, until this bill, as a law unto themselves. And I refer to them as parking cowboys, and that's how I'll continue to refer to them, because that is what they are, and that's how they've been operated. They harass and frustrate our constituents, and they drive away tourists from many towns and city centres. Now, I am sick and tired of getting emails into my office complaining about the behaviour of parking companies, telling me that they will no longer be coming back to my city centre because of the negative experience they've had simply trying to park a car and having the misfortune to end up in a car park operated by one of these parking operators. I have received more complaints about one car park in the city of Perth than any other single issue in my mailbox. One car park in the city of Perth. And that car park is operated by the Lone Ranger of the parking cowboys, the hated and appalling smart parking. And I'm looking round and I'm seeing a sense of recognition by some other members who have obviously had the misfortune to have the dreadful smart parking as a feature of their towns and cities. It's got to the stage, as I said in my earlier remarks, that I've got one member of staff who spends a good part of his day just assisting my constituents and visitors to my constituency to ensure that they can navigate properly the appeal system and process. Yes, of course, I give way to neighbour.
I thank my honourable gentleman for giving way. I am indeed his neighbour, and I can confirm the number of complaints that also I receive from my constituents in South Perthshire and also in Clackmannanshire as well, who visit Perth and have issues with this same provider. So I just want to say how supportive I am of this bill today, and hopefully it means that we can actually get our staff focused on the things that really matter for our constituents and not dealing with car parking complaints, which really are the company's responsibility to fix.
Very, very grateful to the honourable gentleman's remark, and of course I understand totally the frustration of his constituents who have to use some of the car parking to access facilities in the city centre of Perth. So yes, and I hope that him and I could both be reassured that our mailbag on this issue will significantly decrease as a result of this particular bill. But there's one other feature I want to talk about, particularly with smart parking in my constituency, is that they're singularly unresponsive. They do not reply to representations from members of Parliament. They do not have any sort of meetings with us, and they singularly do not even start to engage with some of the difficulties and identify issues that they have about their operation. And at this stage, I also want to commend the Courier in Perthshire for the campaign that they have mounted about the parking situation in Perth. And one of the reasons that we're here today debating this and ensuring that we've got me down here as a Member of Parliament is some of the very fine things that the Courier newspaper have done about the situation in parking right across Perthshire, and I congratulate them because of this. Now, they'll no longer get away with this type of behaviour because of this bill. The days that they can distribute fines like confetti, when they can confuse and frustrate our constituents with their so-called smart technology and poor signage to harvest the fines, will be coming to an end. Now, Madam Deputy Speaker, I think this bill is evidently required, as self-regulation has been an absolute and resolute failure. The current toothless regulators, like the British Parking Association, are singularly incapable of dealing with the sharper practices of the rogue operators. And they actually list them as part of the members. I had a meeting with the BPA this week, and they gave me the magazine, and I went through the list of all their members. Who was there? And in bold letters, smart parking. They cannot take them on. They have not got the ability to do this, and they have shown no sign whatsoever of trying to get on top of some of the practices from some of these things. And what the BPA actually does is give a veneer of legitimacy to some of these more outlandish rogue operators, because they're included in their membership. And that allows them to get away and continue to operate in all this. What this bill will do will be oblige and ensure that operators like smart parking will be able to change and amend their practices. There's one other example I want to raise now that I've got this opportunity, and it's something that's actually worse than smart parking that I observed in a retail park in my constituency. 2 private parking companies operated one huge parking space in a retail park in St Catherine's in Perth. What one parking company did was circle their car park with signs saying to motorists if they had the temerity to leave one part of the parking space in the retail park to access shops in another part of it, they would be fined. And they did that. And they actually took photographs of people leaving their car, going into other parts of the retail park, using facilities that were covered by another parking operator. And this is what they did. This is the extent to which some of these private parking operators work, and it is not good enough, and it has to end. And I want to say to the Minister that I think what he's doing is fantastic. I've seen some of the details that he's going to put into the Code of Practice, which I think is fantastic, and I congratulate him for taking the Maximus approach. I think the government will approach this in ensuring that they'll do the utmost they can to protect the motorists for these type of practices, and they'll set in place a set of regulations that will ensure the best result that we could get when it comes to these things. The type of things I'll make a plea for to be included in the Code of Practice, but I'm pretty certain, given what I've heard from the Minister, that he will be looking at is things like equipment and technology. We've got to make sure that we get the signage absolutely right, and that the surface markings are clearly identified and regulated properly. That there's clear and accessible displays of the terms and conditions in the car park. We've already heard examples when that doesn't actually work. And I know this is something that the government is looking at. It's consideration periods to allow motorists sufficient time to decide whether they would like to park, and grace periods to allow motorists time to pay and leave the car park. All of this would make a real difference to the parking arrangements we have in our cities and towns. I believe that these parking companies intentionally deploy poor signage, and the fact that motorists can be fined for simply entering a car park to look for a space is simply and clearly unacceptable. And one of these car parking operators in my constituency actually fined people for entering a 0 instead of an O, letter O, something that their smart technology apparently can't even be able to cater for. And they take no recognition at all the fact when people appeal on that basis. One of my other pleas to include it in the code, and the Minister might be able to help us with this one, is the capping of the fines. I think that's a feature that we all agree must happen. The fact that you could be fined £140, £160, £180 for parking a car is simply and utterly absurd. So I think and I hope that this will be addressed. My suggestion is that fines or PCNs and private parking car parks should be no more than the local authority. I think that's fair, that there's a uniform cost that you will pay in any city and town across the country, and I'm pretty certain that we'll get to that sort of place. And I know that the government's intention is to ensure that these, as they call them, PCNs, will no longer be able to look like fines from the local authority, and that's really important. And I think, I don't know, but maybe the Minister could tell us how this will be done, how he intends to ensure that that's going to happen. But they have to get away from this confusion with local authority, penalty charge notices, and they must do it in a way where there's not going to be the threatening and intimidating language which is going to be used with this ticket. What I would actually like to see in the ticket is a full set of the legal basis in which these tickets could be distributed. Because my right honourable friend said this is a contractual arrangement. This isn't a fine. And like, if the private parking company is to pursue this, they have to take it to the civil court to demonstrate clearly that the motorist breached the terms and conditions of using that private car park. I think that should be mentioned in the parking ticket as issued by the private operator. And I think that would be fair. Yes, of course.
Way, but if the parking operator takes an erring motorist to court, at the civil court, and in that court it's shown that the form of the private parking notice was not as laid down in the mandatory code of practice, I would argue that should be a case for dismissing the claim.
Totally and utterly agree. And I want to come back to DVLA access later in my contribution, because that's the key. What's all about is the DVLA access, and ensuring that access to that is going to be predicated on good behaviour. And are there any examples of any of these companies getting back to these sharp practices? They will be dealt with effectively and not given access to the DVLA register. But I'm particularly delighted that the government are looking at issues around debt collection. I think the government, and again I hope the Minister will confirm this, is that they're going to explicitly state that operators cannot sell or assign debt to a third party. That has to happen. The use of aggressive debt collection companies is probably the most grotesque, threatening and intimidating feature of the behaviour of parking companies just now. And it's this part of their operation that concerns me most. I can't remember which honourable member made the point about vulnerable customers receiving some of these letters and what that must do when they secure these letters. Letters sometimes telling people that this will have an impact on the credit rating, which I think is actually illegal. Maybe somebody could clarify for me. One of the greater legal minds in here can clarify that for me. But this is the sort of thing that they include at this letter. And what they do is they increasingly increase the tempo and rate of intimidation and threat. I've had one constituent that's received 10 letters from a range of different debt collection companies with a increasing tone of belligerence and threat applied to that. And I believe it's right that PPC should expect settlement and that reasonable steps are deployed to recover it. But we cannot continue to have these threatening and aggressive letters demanding payment simply for parking a car. And we know that all this is about being determined allowed access to the DVLA. This is the prize that the parking companies require to ensure that they continue to operate. And again, that I'm pleased, the right honourable gentleman has confirmed this, the government will be put in place conditions for access to the DVLA database, and that proper auditing will have to be conducted before an operator may join a parking association, and that compliance must be demonstrated. I actually believe that it should be incumbent upon parking operators to demonstrate quite fully that they are a responsible parking operator in order to get DVL access. And if there is any examples of bad practice, DVLA access must be removed. And I'm grateful that this bill does cover the whole of the UK. Every single section of this bill, including the amendment that we've just passed with the right honourable gentleman, will be applicable to Scotland. We've agreed an LCM in the Scottish Parliament which will ensure that this will be allowed and will apply right across Scotland. I think it's right that we have uniformity in issues like this. I travel down to London and park my car here, as honourable members will come to beautiful Perthshire and enjoy the fantastic features that we have in my constituency. And I think it's right that everybody expects the same level of service and regulation anywhere right across throughout the United Kingdom. And we've seen what this does to towns and cities, and I've given examples that parking is an absolute essential requirement for any town centre and city, and the right honourable gentleman is right to highlight how many trips are made and how many parking experiences are operated as a matter of just getting from A to B. And it can have a devastating effect on local economies if we don't get this right. So it's a really important ingredient in our community and the local economy. In my experience, I think people are happy to pay for the parking. I've never seen anybody who's trying to suggest that they should get parking for free. In any place where we've seen free parking operating in the United Kingdom, it's been a disaster and a free-for-all never nearly works. So we do need efficient and effective parking, and we do need to make sure that that is something that continues to happen in the towns and cities. And I think people are actually quite happy to pay like parking fines if they know they've been wrong, if they realise that they maybe overstayed for a little thing, something happened, they realise that a parking fine will be happy. And I don't think there's an issue about that. But what they cannot stand, and why we've seen so much complaints in our inboxes in the correspondence that we receive as members of Parliament, is when this is unfair, when this has been done disproportionately, when there are issues about how people are being pursued by these parking companies, and these sort of things that we have to ensure to do this. And I believe, ultimately, it is not beyond our wit to design an arrangement where somebody could park a car, makes a payment for parking their car, and is assured that that is fine, and that's the end of the matter. And why we are here, having to ensure that we have a code of practice, I think just shows how badly things have become and why we have to address this. But I hope this is high noon for the parking cowboys, and I hope that we do ensure that they are brought under control, and I'm not having to continually respond to constituents and visitors to my constituency about the behaviour of a certain company. It's a very good bill. We now need to see what the code of practice is. I know the Minister will ensure that we are involved in designing this code of practice, and I look forward to hearing some of the features which he could tell us will be included in this when he makes his own presentation to the House on this. I just lastly, once again, to congratulate my good friend, the Right Honourable Member for East Yorkshire, for bringing this bill and ensuring that we're going to be successful today.